Welcome to SCOTUScast, Title VII of the Civil Rights Act edition. Thank you for tuning in. On February 21st, 2017, the Supreme Court heard oral argument in McLane Co v. EEOC. Damiana Ochoa worked for McLane Company, a supply chain company. After returning from maternity leave, Ochoa was required to take a physical abilities test, which she failed 3 times. Ochoa was fired by McLane, but then filed a charge with the Equal Employment Opportunity Commission, alleging that McLane violated Title VII of the Civil Rights Act of 1964. The EEOC opened up an investigation and issued a subpoena for information McLane withheld, including either pedigree information for each test taker or reasons the test taker's employment was terminated. When McLane refused, EEOC filed a subpoena enforcement action. The district court granted enforcement of the subpoena with respect to some information, such as the gender and score of each test taker, but declined to require the production of pedigree information or the reasons why others who had failed the test were terminated. The U.S. Court of Appeals for the Ninth Circuit, reviewing the district court's decision de novo, held that the district court had erred in refusing to compel production of the pedigree information, and also needed to consider whether production of the reasons for other terminations would be unduly burdensome. The question before the U.S. Supreme Court is whether a district court's decision to quash or enforce an EEOC subpoena should be reviewed de novo, which only the Ninth Circuit does, or should be reviewed deferentially, which 8 other courts do. To discuss the case, we have Karen Harned, who is Executive Director of the National Federation of Independent Business Small Business Legal Center. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Ms. Harned.
This is one of the employment law cases on the docket this term, and it concerns the standard of review that appeals courts give to district court decisions when the district court rules on the scope of an EEOC subpoena. And just by way of background, this issue is increasingly important because over the last several years, the Equal Employment Opportunity Commission, EEOC, has given a huge focus of its work to what it calls the looking for systemic discrimination. So basically, they're really trying to go for the biggest of fish, seeing if they can find disparate treatment of some protective class by a company on a nationwide basis. So when a charge is brought against a particular company, an EEOC charge, sometimes, many times, a lot of the employment bar would argue, the EEOC will use their subpoena powers to go when they're looking into the validity of that charge to, basically go on a fishing expedition to see if they can uncover some other types of what they would consider illegal behavior being performed by that company. And so this case really does set up some facts that really kind of speak to that. And in fact, when the case was when McLane put forward their petition for review, they did ask the court to consider 2 different questions. One was the question that the court ultimately granted cert on, which is whether a district court's decision to quash or enforce an EEOC subpoena gets de novo review or it gets abuse of discretion type of review and, or more of a deferential review. And there is a circuit split, but it's just between the Ninth and everybody else. The Ninth Circuit did say and reviewed this case, which I'll get in the facts in a second, by de novo review, but 8 other circuits have had more of an abuse. They've been more deferential, more of an abuse of discretion, more is there a clear, violation of clear error in the law, or in fact, when reviewing what the district court would have done in their different circuits. McLane had also originally asked for the Ninth Circuit or the court to weigh in on whether the Ninth Circuit's actions in this case, their decision in this case, upholding, enforcing this EEOC subpoena that they viewed as so broad, really exceeded EEOC's statutory limits of where investigative powers can go under an old Supreme Court decision of EEOC versus Shell Oil. But ultimately, the Supreme Court declined to go to that second question, at least when it took the case. So what the case concerns is McLane Company, which many of you may know. They basically distribute to chain stores all over the country, different things, different items. And they've got a national presence. And Allison Ho, actually a good Federalist Society member, was the attorney for them at the court and did a fine job today. And when they hire a new employee, they give them a physical capability test. They also give this test to current employees that are returning from medical leaves of absence. And so Damiana Ochoa, a woman, was required to take the test before she was allowed to return to work from maternity leave. And over, I think it was the course of a couple months, she took, or at least a few weeks, she took and failed the test 3 times. So as a result, she was not permitted to return to work. And she subsequently filed an administrative charge with the EEOC, and she alleged that the use of the test discriminated against her based on her sex. And so at this point, this is where some of what I just had provided as background came in, because EEOC asked McLane to provide extensive information about the test, including for everybody that took it. And this is also, it should be noted, I think she was in their Arizona facility, but they asked for the subpoena to cover all of the McLane facilities nationwide. And in it, they wanted what is called the pedigree information, which is the subject of the underlying dispute here, which is the name, sex, date of birth, social security number, and contact information, personal information of each of the employees, their disability status, the why that person was required to take the test, what their score was, and the reason that they were terminated. And it was really this pedigree information, the names, genders, social security numbers, etc., for each test taker that McLane viewed as too broad. They were willing to provide, information on people nationwide that took the test, what their scores were, whether or not they were terminated as a result of those scores. But it was the pedigree information they thought was basically just opening the door unnecessarily for EEOC, going beyond the scope of what the underlying charges concerned. And once the initial charge by Ms. Ochoa was made, EEOC quickly expanded the scope of its investigation to include requests for information that would help it decide if it also wanted to go after an age discrimination claim violation for disparate treatment of workers over the age of 40, even though Ms. Ochoa was not over 40 when she took and failed the test. So that right there, I think, was an indication to the district court that something's going on here beyond just trying to figure out if Ms. Ochoa was discriminated against based on her sex when being given this test. And so, as I mentioned, McLane did go ahead and provide everything but the pedigree information and challenged the subpoena as too broad in the district court and beyond what was relevant to the charges presented. And the district court agreed with McLane and limited the subpoena as a result to, going with the test information and who took the test nationwide and what their scores were and who was terminated as a result, but not the pedigree, not their personal information. And the Ninth Circuit decided that they would review the district court's decision de novo, and in so doing, they determined that the subpoena, as requested by EEOC originally, should be enforced and that McLane should provide the pedigree information. So here we come to the Supreme Court. As I mentioned earlier, the Supreme Court took the case on the issue of what kind of review was to be afforded to district courts. 8 of the circuits say it's more deferential review to what the district courts say. Ninth Circuit's on an island and says no, it should be de novo. And the other thing that was interesting is somewhere along the way, EEOC ended up agreeing with McLane on the standard of review and said, we agree with McLane that it should not be de novo, that it should be, if there's a clear violation or of the rule of the law or facts, that sort of thing, but abuse of discretion review standard. But we think that the result's the same, that the EEOC subpoena would still be enforced, and the Ninth Circuit got to the right result, even though they used a de novo standard, because under relevancy, they said that the pedigree information was relevant to their investigation. And so in the end, both the petitioner and the respondent are arguing that the Ninth Circuit does not have de novo review, that it's best for district courts to have more of a deferential review, but they disagree on what that ultimately means. McLane saying that means the district court got it right and the subpoena should be limited, and the government saying the district court got it wrong, and the Ninth Circuit was right to determine that. They just did it under the wrong type of standard of review, but even under abuse of discretion, they would have gotten to the right place. So as a result, the Supreme Court had to get an appointed attorney, and I'm sorry I'm missing his first name, but his last name is Harned, and he did a very nice job arguing for de novo review ultimately on behalf of the court. Though now that I'm getting into the oral argument and how that went, there didn't seem to be much discussion about how deferential the review needed to be. I mean, de novo versus deferential. It was more getting into the discussion was actually more into, the relevance of the subpoena requests and that were asked of the EEOC and the pedigree information. There was more discussion about that than the standard of review. There was a little initially when Allison was up there was discussion of, is the district court the best to determine this? And I thought she answered that ably, but then they really quickly launched into the relevancy argument and whether or not the pedigree information was relevant and what the standard is on determining that. And that really was, I think, Breyer was the most interesting when we were talking about relevancy, because he did seem to understand that what the EEOC was asking for was giving them much broader authority, and Allison Ho did a nice job of reminding him of the Shell Oil standard and that it has to be, relevant to the charge, but it looked like he was wanting a clear definition of what's in between the two. And, what's the in-between, unbounded authority of EEOC getting to say, well, everything's relevant because, once you start going down one trail of, everybody has to take a test. Well, what does that mean for disabled people, even though the facts in this case concerned a woman that was under the age of 40 and it was a gender discrimination case. So he did seem to understand and appreciate that, and really I thought was positive in that regard. But ultimately, when Mr. Harned got up there and there really wasn't a lot of questioning of him, I just felt like the justices, it's going to be much easier for them just to stick with the question presented, stick with whether or not de novo review is appropriate or if it needs to be a more deferential standard. And really the only one arguing for aggressively, I think, on the standard piece was Ginsburg, who seemed to question whether the district court really had that much of a bird's eye view more than, or a boots on the ground view more than an appeals court when it comes to these questions. McLane's counsel, Allison, said that the district courts are seeing the facts up close, the appeals courts are not, but then Justice Ginsburg seemed to push back on that a little bit. In this particular case, Allison was able to say that the facts were very apparent because, as I had mentioned, McLane was also being investigated by EEOC as a result of this charge for potential disability claim violations and age violations. And so the district court had seen all of that color, but Allison made the point that it doesn't matter whether or not that's the case in every case that the district court gets. The district court is still going to be looking at the case and seeing the facts and the context of the case more than an appeals court ever would. And it just didn't seem like she got much pushback, if any, beyond Ginsburg on that point. And then when you had the government coming in right behind her saying, we agree, and by the way, if you like the Ninth Circuit's decision here that EEOC basically gets to troll for any information that it wants, we can still get there on this deferential standard. So I might be wrong, but I find it a really tough row for the court-appointed counsel, Mr. Harned. Through his creative arguments, he used Administrative Procedures Act, saying that did not allow for a deferential standard. And I thought that was that was really one of his best arguments, but I didn't get the sense that there were a lot of takers on that, on the panel of justices. And when it comes to the issue that a lot of us ultimately want to get cabined, the subpoena power of the EEOC, I'm just not sure the justices are going to do it. It's just going to depend. Breyer did seem open to it. Kennedy is not always wonderful on employment law issues, and given the fact that it's a 4-4 split, unless there's a clear, majority there, it's going to be so much easier for them just to have a nice, at a minimum 7-1, if not 8-0 decision on standard review, ultimately on this case.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.fedsoc.org/multimedia.